give an opportunity for a settlement negotiation to occur. You're not excused. We're still here for the hearing today. So you may maintain your seats. If you'd like to have a conversation with Mr. Osborne, that'll be fine. I'm going to stay right here during that matter. My intention is that we go back on the record here in a few minutes with the rest of our case, unless it's a settled satisfactory among the parties.
I'll leave it out, Joe.
No, stop it.
I don't give a shit. I'm done with this shit. This county has nothing but shit there.
So we just get forced out. So we'll leave. When do we need to leave?
Last thing I do is if you'd like to consent to the eviction, we'll give you 10 days from today to be out. If you're not out by then, we do a writ of restitution.
That's fine.
We have to go on the record and contract.
So we're being forced to leave.
This county is shit. Is that on the record?
Maybe I'll say to you, I've been courteous and polite.
Yes, he has been.
And I've been
Please stop.
trying, but
I would say that you're not trying.
I've been attacked from this county since.
I think we can go back on the record then, on the matter. We're going to go back on the record now. This is a case styled Adams Metropolitan Housing Authority plaintiff versus Eric McKenzie Sr. and Don Chappell. Case number CVG 2400-327. Plaintiff present by and through attorney Mr. DJ Osborne. The defendants, Eric McKenzie Sr. and Don Chappell, self-represented.
I want to continue.
Has found and made a finding that there's a sufficient time to prepare for the hearing. The motion to continue was denied and overruled, and that we were going to go forward with our eviction action. While we were off the record, I believe there has been a broad agreement that the parties would make a few basic agreed findings, and then that there would be an agreed day to be out of the property. Mr. Osborne, I'll give you the opportunity to state what you think the agreement was, and then I'll give the defendant's opportunity in regard to the matter. I think it involved basically agreeing that the property was in Adams County, that Adams Metropolitan Housing Authority owns the property, that the appropriate notices were provided, and that there have been violations of the lease, and the parties are going to agree to be out of the property within 10 days.
10 days, no.
To a written restitution.
Your Honor,
go ahead, Mr. Osborne.
That would be our understanding of the agreement. However, I'm kind of confused on whether we're proceeding with the agreement, because 1 minute I'm hearing we're going to continue with the exhibits, 1 minute I'm not. So my question is, that's our understanding of it. We're willing to enter into agreements with that. If from their side, I don't know if they are.
Thank you, Mr. Osborne. I want to inquire now of Ms. Chappell and Mr. McKenzie. I was here, I never left the bench during the period of time that we were off the record, and there was some conversation that was had toward the purpose of making some agreed findings and then having an agreement in regard to leaving the premises or a vacate time. My understanding, and I will repeat this, I know I'm repeating myself a bit, but it's important that we make sure that we all have this information as a shared piece of information. There would be an agreement that the parties would agree that the court would find that the premises here at 211 Sunshine Avenue, Unit 125, Winchester, are in Adams County Court, Adams County, Ohio, which gives the Adams County Court jurisdiction. There would be an agreed finding that the plaintiff, Adams Metropolitan Housing Authority, is the owner, which is to say Ms. Chappell and Mr. McKenzie, you're not the owner of the property. There would be an agreement that there have been appropriate notices provided to you in regard to the matter back that were part of this. Now, you're shaking your head no, so if you...
There weren't proper notices.
The information that is in the file includes notices that go back. I will say this to you, and if this is something that you don't agree to, it can be something that I can find, that there was a notice to terminate the lease as far back as December 1st of 2022.